Sui generis, my ladies, my lords, in the sense that public participation collected and the views collected cannot alter the content. Why so, my ladies, my lords? Because the bill, whether domiciled in the parliament or domiciled in the county assemblies, is not owned by either of those organs. The bill is owned by the promoter. So can views collected ordinarily alter the content of a bill proposed? For example, I give an example. Could the County Assembly of Kirinyaga say that we are now going to create an executive prime minister? Would that find a sitting in a bill of this nature? Yes, my lord, we submit no. How, my lord? The justice of the Superior Court ought to have applied the doctrine of sui generis while interpreting Article 118 and Article 196, which allows or which brings the concept of public participation. My ladies, my lords, allow me to move to the contradictions appearing in the judgment. To do so, my ladies, my lords, permit me to request you to go with me to paragraph 490 all the way to paragraph 496. And the fundamental question we'll be asking following my submissions is whether a judgment that contradicts itself in this manner is capable of being implemented. My ladies, my lords, at paragraph 490 of the judgment, the judge says that, and I read, it follows that the president has no power under the Constitution as president to initiate changes to the Constitution under Article 256 of the Constitution, since Parliament is the only organ granted authority by under the Constitution. My ladies, my lords, the justice of the Superior Court observed that we need to have a holistic approach to the interpretation of this Constitution. Therefore, on interpreting whether the president has the capacity to initiate amendments, we also ought to have borrowed leave in Article 119 of the Constitution. Permit me, my ladies, my lords, to make just some little reference to the same. My ladies, my lords, Article 119 says, every person has a right to petition Parliament to consider any matter within its authority, including to enact, amend, or repeal any legislation. My ladies, my lords, they ought to have put into consideration these provisions, and as well put into consideration the provisions of Article 27. 27 provides that we all are equal before the law and we enjoy equal protection. What made the justice of the Superior Court to declothe the president of that right of equality before the law? Could it have been the intimidation of the status of the president? My ladies, my lords, we submit thus that insofar as this provision or this paragraph so appears, the justice of the Superior Court failed to apply the purposive rule in the interpretation.
Just a question, Mr. Ndegwa.
Yes, my ladies.
Does any legislation include the Constitution?
Well, lady, that might be jurisprudential and debatable, but here we submit that it's a right that is available to a citizen. And since Article 12 creates those rights of a citizen. My lady, my lords, what did the justice of the Superior Court say? The same paragraph. The president, if he so wishes, can, however, through the office of the Attorney General, use parliamentary initiative to propose amendments to the Constitution. What an observation. Then they further say, under paragraph 496, permit me to read for purposes of clarity. In our view, in interpreting the Constitution, Constitution holistically, as we are enjoined to do so by Article 1 Clause 2, must be read together with Article 256 and 257 of the Constitution. When one considers these provisions together, the only reasonable conclusion is that Article 257 of the Constitution is reserved for situations where the promoters of the bill do not have recourse to the route contemplated under Article 256, which is the parliamentary initiative. Our view is in tandem with the historical genesis of the provisions we have set out here above. In other words, Article 257, my ladies, my lords, route is meant to be invoked by those who have no access to Article 256. Those who have access to Article 256 routes are therefore barred from purporting to invoke Article 257. They have said, my ladies, my lord, the president has no access to that route. Then the further says that Article 257 is only available for the person who has no ability to access parliament. The further says that under Article 94, my lady, my lord, that parliament is the only legislative organ. Are we making our president a toothless dog? Does the president continue to enjoy the rights enshrined in the Constitution, or is he declothed of those rights pursuant to taking of oath? My ladies, my lords, if you go again to paragraph 492, again allow me to read it. Beyond the text of the Constitution, there is another reason it is impermissible under our Constitution, in our view, to permit the president to initiate such amendments through popular initiative, and then sprint to the finishing lane to await and receive it. Where in the facts before the court was it that the president was promoting a popular initiative process? They further say, my ladies, my lords, this is because Article 257 of the Constitution provides that if a bill to amend this Constitution proposes an amendment relating to a matter specified in Article 255, the President shall, before assenting the bill, request the IBC to conduct within 90 days a national referendum to approve the bill. What an erroneous findings, my ladies, my lords. Article 257, Clause 5, does not deal with the president. If you may read, my ladies, my lords, the specified article, my ladies, my lords, it provides that if Independent Electoral Commission is certified that the initiative meets the requirements of this article, the Commission shall submit the draft bill to each county assembly for consideration within 3 months. Could they have made erroneous finding because of the fixation they had with the whole notion of the president? Or was it just an apparent error on the face of record?
Counsel.
Yes, my lord.
What does Sub-Article 9 say?
Of the same?
Yes.
If Parliament passes the bill, it shall be submitted to the President for assent. That's correct, my lord. But yes, that is not what is captured in the judgment. The judgment speaks about the President taking the bill to the IBC. We can only take what is recorded because it's a court of record, my lords.
So, he takes it to Parliament,
yes, my lord,
and not to IBC.
Yes, my lord.
What is the big difference as far as your argument is concerned?
Yes,
what is the big thing there? I mean, you're saying the president has no role at all, but you're saying, but the question says he receives it and takes it to Parliament.
They are saying, my lords.
Just a moment. Yes. They say he receives it and takes it to the IBC. Yes,
my lord. They are saying if an amendment details or touches on Article 255(1), the president, and of course that is emanating from, the amendment is emanating from 256. That is when the president is seized of this function. But insofar as We are dealing with an amendment under Article 257 as it is in these circumstances. It was erroneous for them to find that the president has a role to play. That's our submissions, my lord. My lords, as I sum up, the justice, if you look at paragraph 490, and you look at the finding Roman 3, the justice of the Superior Court declared that a declaration is hereby made that the president does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257. A correct finding. But again, my ladies, my lords, the question is, what was the role of the president in the entire process? The role of the president in the entire process was detailed in Article 131 of the Constitution. What does it provide? That the president has the role of initiating national unity. Where do we get this national unity from, my ladies, my lords? We get it from Article 10. Article 10 provides the principles and values of national of governance. And the president, under Article 132, is mandated to make periodic reports to Parliament on how he has achieved the implementation of Article 10. But does Article 131 tell us the means, the modes, the manner, how the president is supposed to initiate the process of national unity? It doesn't. The law doesn't constrain and restrict the president. He is left to his discretion even to create a task force as such of the Building Bridges Initiative. Was it then possible that the court could then declare the Building Bridges Initiative unconstitutional? We must look at the objects and the purpose for which the Building Bridges was created. Among the fundamental purpose, my ladies, my lords.
Mr. Ndegwa, can you wind up?
Yes, my lords, I'm just winding up. My ladies, my lords, the purpose for the creation of that organ was to enhance national unity. Can we fault the president for doing what is constitutionally his or what is constitutionally bestowed upon him? We submit no. My ladies, my lords, there ought to be equality of arms. When the matter of justice, Lady Justice, Deputy President of the Supreme Court, was brought before the court, she was treated with equality of arms. Why should we declare the president of his glory conferred upon him by the Constitution and clothe one organ with the other? We need equality of arms. Well, ladies, my lords, unless there is any clarification, I beg to rest my case and greatly thank the court for its time.
Thank you, Mr. Ndegwa.
My Lord, I have a preliminary request to make. My Lord, there are substantive respondents totaling 80 numbers. On the 2nd of June, when directions were given, we were given 2 hours each. My Lord, the speakers who are now on the floor did not speak before the High Court. In fact, they were not party to the directions that we took on time. My point is this. If the 8 of us will be given 2 hours, as we're entitled to, is it possible we'll conclude this hearing today or tomorrow? It is not. I therefore humbly request that we stick to the directions that were given. If they are supporting the appellants, let them just indicate they are supporting, because it will be an anathema for the county government of Kirinyaga or Kiambu to come here and say they are supporting the president's position. That's just a humble request.
Thank you, Ms. Harvey. We have done with the respondents who are supporting the petition, and we are now moving to just hold on, council. Okay. We are now moving to the other. Now to the respondents who are opposing the appeal, and we have a total of about 8 16 who filed submissions, and it is not necessary that all of them address the court substantively. We are going to have a number of the appellants respondents address the court. Remember, when we were giving directions, we say that the court reserves the right to restrict time to avoid unnecessary repetition, because all the issues are cross-cutting. And once, for example, the first to fifth respondent, just as an example, have addressed us, the other respondents who are coming to make submissions in support of the first to fifth respondent's position need not take even half of the 2 hours. And that's why we said each side to organize themselves to determine who is going to address some of these thematic areas. We cannot possibly have each and every respondent having 2 hours. So that is the way we look at it. We have to finish this matter by tomorrow. We have sufficient time to do so. What's your name, counsel?
Your Lordship, my name is George Gilbert. I appear for the 71st respondent.
70?
71st.
Who is that?
Felista Wakesho. I filed my submissions. I'm coming in support. Sorry, Your Lordship.
You come in?
I'm coming in support of the appellant.
Yes.
And I promise to this court that I will not even ask for the 20 or 30 minutes that my previous predecessor took. I am going to take maximum 10 minutes. Maximum.
Are you addressing us on a different issue, or you're basically highlighting an issue that is already on record?
I'm going to do a very simple highlighting of the Kivitu case of small relevance. Then I'm going to say something very small on the legislations that were decided that are required by the court for a referendum to proceed, making the referendum unconstitutional because of lack of legislation. I promise I will not take more than 10 minutes, Your Lordship.
Did you file submissions?
Yes, I did.
Can we see your submissions first?
They are dated the 23rd of June.
So, Mr. Gilbert?
Yes, Your Lordship.
We'll give you a maximum of 10 minutes. Start at 5.
I promise, Your Lordship. Now, Your Lordship, as I start my submissions, it is very important that I refer you to the judgment of the Superior Court. The copy I have is found in Attorney General Supplementary Record of Appeal, Volume 1A.
So your opening remark is that you're supporting the...
I am supporting the appeal in its entirety. I am supporting the submissions of all the parties who have come before me.
Okay.
And I associate myself fully.
All right, go now with the substantive issue.
Now, Your Lordship, I refer you to court framing its issue, which is found at the page 5 of the judgment of the court, basically on the basic structure. In declaration number 2, the court is persuaded to consider chapter 1, chapter 2, chapter 4, chapter 9, and chapter 10 of the Constitution to be the relevant chapters that are part of the eternity clause or the basic structure of the Constitution. Your Lordship, Article 255(1), A to J, if you look at it keenly, it actually encompasses all the chapters that are represented in that declaration that is sought. That is the position of the court. That was the position of the petitioners in the Superior Court. Your Lordship, it is true to say, as Professor Njiru said yesterday, that in many occasions the terms basic structure, eternity clauses, and unamendable clauses is used like interchangeably. If you look at 4 on the same page 5, it is the same chapter 1, 2, 4, and 9. We submit that the same chapters that are being talked about are the same chapters that appear in Article 255, 1A to J. Now, Your Lordship, what is so special about 1A to J of 255? It picks out of all the preceding 245 articles of the Constitution, the drafters picked special 10 of them, 10 articles, A to J, and said these are basic and core to the principles and values of this Constitution. The people of Kenya saw in their wisdom that 10 of all those articles are very important to this Constitution. What do they say about the 10? They say every other thing save for these 10, you must take it to a referendum. Your Lordship, if you go to 256 on the parliamentary initiative, 5A, they say that you can do anything, but when it comes back to the ones mentioned in 255A to J, go to a referendum. Your Lordship, go to 257.10, Article 257.10. They again say that if you want to touch on the 10 in A to J 255, go to a referendum. Your Lordship, I submit at this moment. There is a reason and a special and specific reason for those A to J in 255.1 being mentioned and say, for these ones, go to the referendum. Now, Your Lordship, I'm submitting that while the framers drafted and Kenyans passed that constitution, they very much understood the historical context of the country and the various attempts to amend the constitution, that they decided to say that these are special. Your Lordship, at this moment I pose the question: what is more important in a constitution than the Bill of Rights? What is more important than the independence of the judiciary? Those are the matters that the framers and the enactors of this constitution say, these are special, but they must go to a referendum. Your Lordship, my predecessor spoke about Kivuitu, and I hope you've not taken it off your desks. In the Kivuitu case, I want to specifically refer you to paragraph 158 and paragraph 159, specifically. Your Lordship, as I do that, it is important that I remind this court that Kivuitu is a three-judge bench of Justice Weldon Korir, Mumbi Gugi, and G.V. Odunga. The judgment was delivered by Justice Odunga.
Please remember your 4 minutes, counsel.
Yes, I know, Your Lordship. 158 says, we agree with the sentiments by Ringera Jerry in Joya 2, that an amendment that upsets the basic structure of the Constitution could not be effected by the Parliament without involving the people. That's what the three-judge bench says. Without involving the people is the important word. So the court realizes that according to it, it thinks those are the basic structures, and you must involve the people to be able to turn the issues in A to J, the matters, they must go to a referendum. 159, this is what the learned judges said. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in Joya 2 case was necessary. They are talking about the history of disrespect for the sanctity of the Constitution. Then they say, this may explain why the people of Kenya are aware of the frequent and frivolous amendments to the repealed constitutions provided in Article 255 of 210 Constitution, that the special core factors of A to J. Your Lordship, paragraph 162 of that judgment, they give an example of the independence of the judiciary. And they say, as an example, 255(1)G provides for amendments related to the independence of the judiciary, which should be approved by a referendum. So, Your Lordship, is it possible that what is being told to this court as a basic structure is not an amorphous organism put above the Constitution, that again, as we say, as statutes, we look up to the Constitution? Does the Constitution look up to another document that is amorphous, known as the basic structures? In fact, the judges in this court seem to suggest that what they would consider to be the basic structure of a constitution is actually the A to J in 255(1). And they say they can be amended as long as there is a referendum. That's what they say. And they say that specifically and expressly in the places that I've said. Your Lordship, when you retire, look at Kivuit well. Finally, when you're talking of the rules of if you want to amend, because the court made a finding that if you want to amend through a referendum, it is unconstitutional because they are laws for referendum are not enacted. You also see chapter 6